Good morning and welcome to the German Council on Foreign Relations, the DGAP. It is a pleasure to have you here with us this morning. My name is Tim Hofmann and I'm an editor at the magazine Internationale Politik, published by the DGAP. Today we are looking at what could prove to be a defining moment for climate action worldwide. In 2023, the United Nations General Assembly adopted a resolution asking the International Court of Justice to weigh in on two crucial questions. What are the obligations of states when it comes to addressing climate change? And what are the legal consequences when states do not meet or breach these obligations? So, for the very first time, the world's top court took up this issue, and yesterday it delivered its long-awaited opinion. This verdict comes at a time when the impacts of climate change are no longer a distant threat. Climate extremes are intensifying, endangering the lives and livelihoods of communities and entire nations. Therefore, expectations for the World Court's opinion were high, with many hoping for legal clarity on what international law requires states to do to combat climate change. So, clearly, there is a great deal to unpack and discuss today. Key messages of the opinion, its broader implications, the evolving role of climate litigation, both internationally and domestically, and the role Germany can and should play in all of this. To help us navigate these very big questions, I am delighted to have a fantastic panel with us this morning. First, we have Markus Gehring. Markus is an associate professor of European and international law at the Faculty of Law, University of Cambridge. Markus also advises the Climate Law and Governance Initiative. Thank you for joining us. Next, I am pleased to welcome Joana Setzer, who is an Associate Professorial Research Fellow at the Grantham Research Institute on Climate Change and the Environment at the London School of Economics and Political Science. Since 2020, Joana leads the Climate Change Laws of the World project, which is, in fact, the most comprehensive global resource on climate policy and legislation. We are also joined this morning by Francesca Klein, legal advisor for strategic litigation at Germanwatch, a German NGO focusing on development, environmental protection, and human rights. She previously worked as a research assistant at the Institute for Climate Protection, Energy and Mobility, and as a lawyer at the environmental rights organization Klein Earth. Good morning. And last, but by no means least, a warm welcome to my colleague Tim Bosch. Tim is a research fellow in DGAP's Center for Climate and Foreign Policy, where he focuses mainly on the security implications of climate change and the foreign policy challenges arising from the green transition. So now, before we begin, a quick note on housekeeping. This event is, as per usual, being recorded and will be uploaded subsequently. We will start with 5 minutes of intro remarks from each of our panelists, followed by an open discussion and Q&A after about 30 minutes. If you would like to ask a question or share a comment, please raise your hand. And when invited to speak, kindly introduce yourself briefly and keep your question concise so we can include as many voices as possible. Finally, a special thanks to everyone who helped prepare today's morning briefing, from our events and communications team to the colleagues at the Center for Climate and Foreign Policy. Thank you. All right, with that, let's dive in. First, let me hand over to you, Markus. Could you start by giving us a brief overview of what the International Court of Justice actually said in its advisory opinion, and why does it matter? And maybe you can highlight 2 or 3 key messages, and maybe you can even explain us what actually an advisory opinion is, because I think most of us are not familiar with that legal concept.
Yes, thank you very much, Tim, and thank you to the German Council for Foreign Relations for inviting me. I think it's fair to categorize yesterday's advisory opinion in really momentous terms, right? I think the terms to describe yesterday's opinions were landmark judgment, or as our colleague Philip Sands called it, a coming of age for climate law. I think we shouldn't underestimate the momentous decision that the ICJ took yesterday unanimously, which has been quite rare in recent times. So this is really the entire World Court coming together and issuing a legal opinion on one of the world's biggest problems, as those who were behind the advisory opinion always said, right? We want the highest court of the world to answer the world's biggest climate law question. And the court delivered. The court's advisory opinion is momentous. It touches on grounds that most commentators, including myself, thought the ICJ would be too cautious to even touch on. Now, let's start perhaps a little bit with what is an advisory opinion. I often read, oh, it's non-binding. And that, as someone who teaches international law, gives me a slight moment to pause, because of course it's an authoritative opinion by the World Court, and of course it binds the institution that has asked the question, right? It does not bind individual states, but it binds the General Assembly and by extension the UN system. So anyone who underestimates the legal value of advisory opinion should review. I know some of my colleagues in London told the UK government to just ignore the Chagos advisory opinion because it was just advice to the UN. And then here we are 10 years later, and the UK is handing over the Chagos Islands because of the advisory opinion. So the long-term effects of this opinion will be with us for many years to come. And I think some of the books on climate law will have to be rewritten. And just to give you a few glimpses, because I think we can come back to some of the substantive aspects. The court first finds that the case is admissible. That was no surprise. What was then slightly surprising and to all of us pleasantly surprising was the deep dive into the climate science. The judges had a briefing by world's leading climate scientists, the Intergovernmental Panel on Climate Change, and cited their reports extensively. And then proceeded to highlight the many obligations under the UN Charter, especially under the climate treaties, right? The UN Framework Convention, the Kyoto Protocol, the Paris Agreement. And in interpreting those treaties, highlighted and clarified some of the legal questions surrounding those treaties. What I found most interesting was then the subsequent parts, because the court's analysis didn't stop there, even though it had been urged by countries like Germany to please only focus on the Paris Agreement and nothing else to see. Also resoundingly rejecting, even in the oral presentation, the positions of the United States and Saudi Arabia, for example, that had basically said there is no room for any other legal considerations. There's no room for human rights, for customary international law because of the specialized climate regime. And the ICJ resoundingly rejected those claims. I found the customary international law analysis on the legal duty of states not to cause significant harm very intriguing. It means that even if your country, say you're the United States, withdraws from the Paris Agreement, that doesn't mean you are without any climate obligations, right? The court has a very careful analysis what is significant harms, what are the obligations for states under this preventative principle, and in the end comes to the conclusion that if you are in full compliance with the Paris Agreement, if you have an NDC which really contributes to the long-term objective, and clarifying in the process that the 1.5 degrees is the best available science, so all countries should actually aim to achieve that temperature goal collectively. If you're in compliance with all those climate obligations, then you are probably not violating the customary law obligations not to cause significant harm. Whereas if you're not, and if you don't have an NDC and you're violating procedural and substantive obligations under the climate treaties, well, then you are. And the court then doesn't stop there. It proceeds to the second question the General Assembly had asked about the legal consequences. And there, we have the ALC articles on state responsibility fully cited in all the legal consequences. I think some countries will be struck that authorizing new fossil fuel developments, giving subsidies for fossil fuels could constitute a violation of primary obligations, which then could lead to legal consequences. For example, cessation of those violating activities or even compensation. And I know the compensation part has made most of the headlines. Of course, the evidentiary thresholds are quite high, even under this advisory opinion. On the other hand, the mere fact that the court does not say, oh, all loss and damage discussions have to be confined to the Paris Agreement, but opens the door to general public international law, state responsibility claims, is in itself resolutionary. And if we are in any doubt where the judges stand, the opinion ends with the word climate crisis, right? So really highlighting the urgency. I was struck that 7 or 8 of the individual judges would have gone much further than the main body of the opinion. And so that gives me hope for the future. I think this advisory opinion is momentous.
Thank you. Thank you for that initial assessment. So the court delivered, and we shouldn't underestimate the legal weight of the advisory opinion. Joana, turning to you, what stood out to you in the ICJ's advisory opinion? And maybe as a follow-up, do you think this legal blueprint will actually make it easier to hold major emitters accountable?
Thank you. Good morning, Tim and all, and good to hear already Markus' views on the real importance of this advisory opinion. So yeah, I guess we're all now, yesterday we were all reading, and now it's good to hear some of this analysis. And definitely lots to talk about. I thought for me, 3 main issues are of real importance, and I'm thinking from a perspective of what might be used in future litigation. So I think that that's kind of my angle here. So the first point, which Markus already alluded to, is that the clear binding obligations that emerge from this. So that all states have that binding legal duties to protect the climate system, and that is not just limited to the Paris Agreement, but across a spectrum of legal sources. That is really important because, as Markus said, it's not about being non-binding or being limited to one agreement. We have this point about customary international law made there. So it doesn't matter if you sign the treaty or not. What is based in unwritten binding binds all states. So I found that extremely important, especially considering how much distraction goes into the binding, non-binding discussion. This is not symbolic, and I think it will be very important to communicate that well. With the media, I had a few conversations yesterday. It's always on the non-binding, so I think we'll have to really be very good in when we teach students, when we speak about what it means and explore, and really highlight the importance of that aspect. So that would really lay a strong foundation for courts, and courts will be able to clarify what that states cannot opt out of their responsibilities. So I'm also looking forward to seeing how that will be translated into litigation and how courts will respond. On that point, of course, courts won't talk by themselves. This will have to be brought by lawyers, by litigants, and it will be brought in both ongoing cases when possible and in new litigation. So I think that's what will be really important, how it is for these issues are framed in existing and new litigation. And then we have to wait until the first judges are engaging, but they do have this opportunity in front of them. I think I wanted also to emphasize the 1.5 goal that was brought, because on one hand, we this year for the first time the science communicated that we're past the 1.5. So I wonder how the court, the ICJ, was dealing with this, because probably by then they knew already, and yet they decided to make it clear that 1.5 is legally binding. It's not just aspirational, and this reinforces the scientific consensus. So what Markus said about the science informing, this is very clear, and the court wasn't tempted to say, well, yes, the science said that, but maybe, it's too late. So it sticks to this point about the translating the enforceability of expectations for states based on science, which is crucial. So the science already said this long ago. The court this time emphasizes and keeps the 1.5. I find that the issue of like in practice, what does it mean, which is how states will breach their duties, and the detail of the EIA and even the downstream emissions of the EIAs, environmental impact assessments. That was really also beyond what I was imagining. I didn't think I never would imagine the court would say that even downstream emissions will have to be measured. And that's hugely significant. If you think about precedents such as Finch in the UK, that small one word about measuring downstream has created an obstacle for permitting new oil and gas in the UK and in other countries that is enormous. So it's things like this, these hooks for future litigation, that I think we are really before something hugely important. And of course, the point that the court held that states might be held even for small contributions. So that, drop in the ocean, the minimalist argument that we heard again and again and again, really excellent to see the court saying, come on, guys, stop with this. So to close, we have to definitely also recognize the victory that already happened in terms of legal mobilization, because that even if we hadn't had this incredible AO, that would have been already a victory. And of course, now even more, the fact that this starts in a classroom with law students and gets where it got that is really, I think, also something that we have to keep in mind in terms of legal mobilization, youth movement, coordination, growing from students to states to all the NGOs, and this is really a story that the lawyers that will focus on maybe the nitty-gritties should also not forget. So the voices of vulnerable countries are amplified. The power of youth movements, of civil society, lawyers across the world, I think, is confirmed. And now it's about seeing how this is going to go from now on. So it's the new beginning, and definitely the call for action and many opportunities already with COP. The timing with COP ahead is quite, I think, positive. So
thank you.
It's in our hands.
Thank you. So not symbolic, communicating this opinion is important. And you also touched upon the question of how this opinion will be translated into domestic litigation. And this is where I would like to bring in Francesca. My initial question to you is, to what extent do you think can this opinion by the world's top court shape future climate litigation, both at the international, but also at the domestic level?
Thank you so much, and thanks also for the interesting points raised already. I can agree with a lot of that that has already been said. In terms of the implications for domestic climate litigation, I could speak a bit more specifically about the German context because that's where Germanwatch conducts its cases. And I think for one, the ICJO significantly increases the chances of success for a constitutional complaint that Germanwatch has launched along with others. And it's currently pending before the German Constitutional Court. It's aimed at the Climate Protection Act. And what we demand there legally are more ambitious climate targets, an effective governance mechanism, so an effective mechanism if targets are not reached, and concrete reduction measures in sectors lagging behind, like the transport sector. And I would say the ICJAO offers support for all of these arguments. So concerning the level of ambition, we have the statement by the ICJ that the 1.5 degrees temperature limit is binding and NDCs must be aligned accordingly. And we see that the CPA is not aligned with the 1.5 degrees limit. And then the situation we have in Germany is a few years back, 2021, the Climate Protection Act was amended and improved, and then last year was significantly weakened. And though the targets weren't changed, the implementation mechanism was weakened, which leads to higher emissions. And the ICJ clearly says there is no room for regression. So NDCs have to become more demanding over time. So that's another argument that's very useful in our constitutional claim. And then concerning the implementation, so as I said, we argue we need concrete reduction measures, we need an effective governance mechanism. And the ICJ here says that the implementation of NDCs is decisive. So states have to take necessary measures to achieve the objectives set out in the NDCs, and they have to show their best effort. And in Germany, we just see that the concrete legal obligations for emission reduction measures, for instance, in the transport sector, were abolished. When we look at the expert opinions, the scientific opinions on this, it's clear that this will lead to Germany missing its climate neutrality target. So that does not constitute a best effort. Then I think more concretely for domestic litigation, I can agree with what Joana has said on significant implications for new permits for fossil infrastructure. So in Germany, for example, we see renewed permits for lignite mines. We just recently saw a permit for new gas drillings off the coast of Germany, LNG terminals. And actually in those cases, we constantly face the argument that the emissions occur downstream, and that's why they don't concern that specific project. So it's really great that the ICJ explicitly mentioned that. And I think it was very valuable that the ICJ explicitly said the failure to take appropriate action, including the granting of fossil fuel exploration licenses and subsidies, may constitute an internationally wrongful act. That's a very, very powerful statement and really calls into question the permissibility of these new fossil projects and will have an impact on the claims that are currently challenging these new permits. And I would also say, for the German context, this ICJO is very timely because on a political level, we're seeing the climate neutrality target being called into question. We've seen the German chancellor use the drop in the ocean argument once again, calling into question whether Germany's contribution even matters. And that's why it's really important that the ICJ clarifies there's a duty according to customary law to cooperate. Every state, particularly industrialized states, have climate obligations. There's no room for regression. And I think this is very, very valuable for the political discussions. And I can assure you that we will definitely reference the ICJAO in our written statements in the cases that we are bringing, and I'm sure others will do that. So I'm very confident that this AO will play a significant role in particularly German climate litigation. And I'm a little more confident than I was before that these cases will be more successful thanks to the ICJAO.
Thank you. So also a great deal of enthusiasm here. I would like to, before I open up for questions from the audience, Tim, I would like to bring you in. Maybe you can build on that, what Francesca just said, and tell us a little bit more about how the opinion could potentially impact Germany's climate action agenda and also its international commitments.
Thank you, Tim. Yeah, and good to be here with you and the colleagues that have already spoken from legal and political perspectives. I want to add maybe and build on what's been said prior by starting and saying that the 1.5 degree warming target identified by the court is, I think, really significant and impactful. So as has been briefly mentioned before, the 1.5 degrees global warming target rather than 2 degrees has been identified by the court as the primary temperature goal that states have agreed under the Paris Agreement. And so it not only has a solid basis in science, this temperature target, this more ambitious temperature target, but also represents, in the opinion of the court, a political consensus that binds states. So why does this matter? It matters first because past 1.5 degrees Celsius, the risks to human and natural systems from climate change increase rapidly. And going past 1.5 degrees would extremely elevate the risks emanating from climate change. And so this is important because the court builds on science to make its argument, but it also builds on what states actually say they want to do. It references the conferences of the parties that refer to the 1.5 degree target repetitively. And so in terms of policies, it means that states taken together, in my view, will need to increase the ambition because the current policies and actions are not in line with the 1.5 degrees target. For instance, the court cites the Intergovernmental Panel on Climate Change, the preeminent institution on climate science, writing that global warming is more likely than not to reach 1.5 degrees Celsius or before 2040, even under a very low greenhouse gas emissions scenario. And so while the court did not establish a precise number on emissions mitigation pathways, climate science has modeled a range of emissions reduction that would need to happen to keep 1.5 degrees within reach. For instance, it's been estimated that for 2030, it would require some 40 or 45% less emissions than are currently projected under policies and actions taken by the global community. And so because this window to keep 1.5 degrees within reach is so rapidly closing, emissions reductions are required at the global level now. The question is, of course, what does it mean for each individual state, right? And I think here the ICJ's opinion clarifies some of the criteria that would determine the different responsibilities of individual states. I briefly want to mention that there's been some debate, and this was also raised during the hearings in this process, to what extent historic emissions should be considered in establishing each country's responsibility. Developed economies are looking for a more dynamic approach that assigns larger responsibilities to rising emitters, while emerging and developing countries argue that there's a legal and moral responsibility for historic emitters to reduce emissions first and foremost. And so the court has said, and this is a quote, that the obligation varies, quote, depending on historical contributions to cumulative greenhouse gas emissions and the level of development and national circumstances of the party in question, end of quote. So the court confirmed that major emitters bear a special responsibility. And these obligations are meaningful because it's now more concrete what countries have to do, right? I mean, they will have to align their policies with 1.5 degrees rather than 2. And I think this is important politically and legally because, as we have already alluded to, states face legal risks if they fail to meet these standards in the future. So this advisory opinion was not regarding any specific state's actions or inactions, but in the future, non-compliance with what the court has said is the legal standard gives rise to the full range of consequences legally, as Markus has said, including the cessation of illegal actions and potentially reparations and compensation. So if a future case has to deal with individual states' obligations, the court would need to make concrete determinations about each country's climate policies. And this is quite significant and should instigate further action, especially by large emitters.
Thank you, Tim, and thank you to everyone for the intro remarks. We have a first question from the audience, Hartmut Fischer. I was just about to ask the question that you that you handed in beforehand, but I'll leave it to you to ask that question here in person.
Thank you. Yeah, my name is Hartmut Fischer from the small climate think tank Germanwatch group. The 1.5 degree limit looks like it's either been reached, that's the numbers we have, or will be reached within the next 5 years. That's the World Meteorological Organization's estimate with 80% probability. So it's basically now that the 1.5 degrees have been reached, also in a scientific sense, not just in one past year. And the follow-up question is, I mean, target setting and then developing measures and then seeing what they generate. And if that's not sufficient, then you can go back to court on that. But that's in itself a 10-year process. My question is whether this is a sufficient basis to, on a national level, to stop further investment in fossil fuel from exploration through gas-fired or coal-fired power plants all the way to buying gas heating systems in homes and combustion engine cars. Because everything that's bought now will be there for 10 to 20 years and will emit further CO2, and basically there's no more room for that. We already have the installed base that's emitting. And secondly, to stop subsidies for fossil fuels, of which there are many, and but they are enormous, and pulling them would be a very strong direct impulse for switching from fossil to renewable energy. So is this sufficient to drive concrete measures that have direct impact on emissions, like stopping fossil fuel investment and stopping fossil subsidies, quote unquote, now, working its way through the course now means in the next 5 years, probably?
Great question. Thank you. So the impact of the opinion on fossil fuel investments and subsidies, who would like to answer that question from the panel? Or do you direct the question to any specific panelist?
Well, being from Germany, I would be interested in Germanwatch's view on that, but obviously anybody who...
So maybe we can start with Francesca then, and you're free to step in then.
Wonderful. Yeah, thanks. Very, very interesting question. I mean, in Germany, we have the principle that all law must be interpreted in line with international law. And for instance, we have one very concrete legal provision in the Climate Protection Act, which states that all public authorities, all institutions taking on public tasks must regard climate protection in their decision making. And this is exactly where the ICJAO can be used to interpret this clause, which is quite vague actually, but it actually concerns all decisions, and it concerns a wide range of institutions that make decisions in the public realm. So this is exactly the provision that I would use, for example, to challenge, for instance, an administrative decision concretely granting subsidies, or an administrative decision granting a permit for fossil infrastructure. Obviously, court procedures also take a while. So whether we will actually then have a result in time is another question. So I think at the moment, it's just very important to actually explain the contents and the consequences of this ICJAO to make sure we can build political pressure to actually reach political or to introduce political measures in a timely manner. I would always prefer that to litigation, but if policymakers don't take this ICJ as serious as it is, then we will have to turn to litigation. And I think with the ICJAO, we have a really strong line of argument that we can use domestically.
Thank you. Next question from the audience, Kira. Floor is yours.
Hi, good morning. My question is to Joana Setzer on the drop in the ocean argument. If you could elaborate a little bit more what the ICJ ruling has actually said on this, or how this pertains to this argument, because it's really relevant for us in Germany, as we are a relatively small country with substantial emissions. However, this argument has been used by Friedrich Merz multiple times on the 2%. It was touched upon already, but I would like to hear a bit more on why this notion that we don't have to do so much because we are only contributing 2% is challenged through this ICJ advisory opinion. And my second question is, I have read that there is a lot of mentioning of implications for small island states regarding their statehood and also the national boundaries. If one of you could elaborate on this as well, that would be fantastic. Thank you.
Thank you for this question. So this point about the drop in the ocean is one that yes, Germany has made, but also most countries involved in this kind of, we call it framework litigation that aims to get further ambition from countries have used in their defenses. And so there's that, but also there's another question, which is whether developing countries, we used to call them, also had to contribute considering their historical emissions. So I think that there are these two interesting angles in the AO. And so in regard to the developing countries, it says that even if historically they had contributed less, they might have to also have obligations now. So I think that's also an important angle of kind of bringing everyone on board. And with regards to the drop in the ocean, I'm trying to find here in the full decision actually the paragraph that was I have so many notes in my PDF that I lost track of where that is. I wanted to find the exact wording, but if anyone knows the paragraph, then please tell me. Otherwise, I think that's the issue is really clarifying that line of defense, and the reason I wanted to say the exact wording is that I thought it was very cleverly written. But anyone knows, Markus? Do you have it there? I saw you nod, and I can't find the paragraph.
No, I don't have I
Yeah.
agree with saying it's cleverly written, and
I'll find it here.
Exactly.
The 140 pages PDF with markings is now too messy. But so the issue is it's if you look at Urgenda, if you look at all the other climate cases in which the courts also dismissed this argument, it took long time for litigants to demonstrate that was the case, and not always they have been successful. So for me, what this AO does, it really supports many of these efforts in simplifying how much effort it will take litigants to demonstrate that that's not a line of defense. But bear with me, and I will, if I don't find it immediately, I'll put in the chat box. 277. Thank you, Francesca. So just to finish and then passing to someone else, it's the way it says here is that although individual states' historical contributions differ significantly here, in the sum of all activities that contribute to greenhouse gas emissions over time, not any specific emitting activity which produces the risk of significant harm to climate change. This does not mean that individual conduct leading to emissions cannot give the rise to obligations to prevent significant transboundary harm, even if such activity is environmentally insignificant in isolation, right? That's so important, because it goes point by point on the transboundary angle, on the quantity, and I think that's a really important contribution. And thanks, Francesca, again.
Thank you, Tim.
Thank you. Yes, I just want to add to that by saying that later the court also says that the fact that multiple states have contributed to climate change increases the difficulty of determining whether and to what extent an individual state's breach of an obligation would cause significant harm, but that prior already the court has considered that customary international law says that states can be held accountable even in situations where there is a plurality of injured states responsible. So it goes in the same direction. I briefly want to come back to the question of small island states, which has been mentioned, and the questions in that context. So I thought one remark that was important that the court made is that it reflected on the question of whether loss of territory of small island states would mean that these states might lose their statehood. And the court says that they basically reject this opinion. They say that loss of territory, once the state has been established, would not mean that the state loses its statehood. And so this is quite important, I think, for small island development states.
Thank you. So I saw, Francesca, you already answering the questions in the chat. If there is a good overview in which countries worldwide court cases are listed. Thank you very much for that. I would bring in Markus again for a legal question, let's say. I was wondering how did the court yesterday define its role, its own role, and also the role of law in general in addressing the climate crisis, and did it acknowledge any limitations to the extent of which courts or the law can play a role in global climate governance?
Yeah, thank you very much, Tim. For all of us as lawyers, I think the last paragraph of the opinion is going to be mandatory reading, because it highlights that the court is aware that law plays a really important role, but is only one part of addressing the climate crisis, right? So the court is acutely aware that just by rendering this legal opinion, we're not going to get rid of climate change as a phenomenon, and therefore it really requires whole society effort in all countries and cooperated globally. What I found, and I said that at the beginning, what I found interesting, and the court hasn't done this in the past, is really this turn to science, right? So analyzing the IPCC reports and highlighting the significant scientific evidence. They even, to the drop in the ocean question, they even give a scientific answer and say, yeah, maybe 10 years ago, maybe 20 years ago, we didn't have the ability to actually determine who has contributed to this problem with exactitude. Now we do. And that opens, you know, the avenue to liability that allows us to determine the very direct human rights impact. I mean, we haven't talked about the human rights dimension of the court of the case as much. The opinion underlines the human rights violations that can occur when the climate crisis is unaddressed. They also highlight that especially industrialized states have an obligation to help developing countries adapt to climate change, right? So these obligations were debated for the last 20 years. Now we have a very clear legal opinion. And one last maybe sentence to Hartmut. Hartmut, on the investment law question, I strongly recommend to read the declaration by Judge Cleveland, because she explains very eloquently that business as usual in investment law terms, disregarding the impact that fossil fuels have, Joana highlighted the downstream effects, in her view also constitutes a violation of international climate obligations.
Thank you. I'll look that up.
Thank you very much. I would like to look a little bit in the future and what happens from now, starting from this opinion. So to the panel, what steps really needs to be taken now to build momentum? I mean, there is the momentum right now, but to really leverage it. And how can it be assured that this opinion, which clearly has legal weight and moral authority, which you all said, but how can it be ensured that this opinion can actually impact the behavior of states? So what is sort of the timeline now that you hope for? And maybe we begin with Francesca, if that's okay.
Yeah, so for us, a concrete measure is, as I was saying, referencing the ICJO in our written statements and the procedures. And so we have our constitutional complaint where, I mean, the Constitutional Court said they would want to decide upon it this year. So we will probably be submitting a written statement shortly. And decisions by the Constitutional Court are directly binding for all state institutions in Germany. So if the German Constitutional Court would say the German Climate Protection Act is insufficient and declare it unconstitutional, the German government would have to amend the Climate Protection Act in line with the court decision. So I think that could be a very concrete impact. And if it follows our line of argumentation, that this would also require concrete emission reduction measures in the transport sector. So I think that's a very potential tangible outcome. I think we just have to make clear that if 1.5 degrees temperature limit is the decisive limit, not only do we need to reduce emissions drastically, then for sure it's a no-brainer to say we can definitely not support further fossil fuel expansion with new permits, and we can't invest financial means to support fossil fuels. So I think we really have to leverage this decision to also flag the financial consequences through reparations that behavior, wrongful acts according to international law can have to really make tangible also for politicians that this could have consequences. And I think it will mean really pushing for climate finance, but also emissions reductions in the next COP, but nationally as well, and then integrating the line of argumentation of the ICJO in ongoing litigation. But I'm sure it will also trigger and inspire new litigation to build more political pressure.
Thank you. Maybe Joana, maybe you want to add to that. You have a great overview of like global climate cases going on. Maybe with a little bit more global perspective, what do you expect? What measures are individual countries or group of countries are likely to take now?
Yeah, so drawing from what Francesca already described, which is very much, I think the way I'm seeing is as I said, is integrating in the existing, but also in terms of the maybe 2 points that I would add. One is the subsidies issue. I think that is a very still present policy across countries that has not yet been challenged successfully. And my hope would be that we would see this AO informing and strengthening that the challenge to subsidies. Now, the other issue, which I think it's very important, is legislation, and Francesca alluded, and we don't want to depend on each litigation to bring, the AO and make eventually the court change. What will be, in my view, extremely important is that this starts informing legislation. So it was good to hear what this might inform in terms of changes in Germany. And in many ways, the AO give that steps of what legislation should have. And I think that's going to be absolutely crucial, that the AO is informing and changing legislation. So I think these would be my 2 key points now.
Thank you. So before I ask the final question, I want to pick up a question from the chat. It's quite long, but I think what I find interesting in that question is, what does the role see for citizens, so for civil society, in contrast to these like big major emitters countries, but also of course companies. So where's the role here for civil society? You already said that this all began with a student-led campaign from students from the Pacific Islands, but yeah, where's the role for civil society here in all of this? Maybe Tim or someone else. Feel free to.
Sure, no, I'm happy to. I was actually just starting to type in response to that question, so this is good. Yeah, thanks for the question about the kind of distribution of task between civil society, private actors, companies, private citizens, and the state. So, of course, the ICJ's jurisdiction here applies to the system of nation states, and it addresses the obligations of states here. But two things that are important, I think, is that the state first submits NDCs, which regulate kind of how emissions evolve in its country. So nationally determined contributions will have an impact on climate policies. And then second, the court's opinion clearly reiterates the state's duty to regulate, and this includes private actors. So I'm saying this in response to the remark in the chat that says that the large majority of emissions today comes from a handful of countries with historical emissions background, and whether we should not maybe focus on getting them to agreeing to reduce emissions first. I think this is not per se excluded. I think the court has made very clear, as I tried to say in my input statement, that historical emissions do count for the question who has to take responsibility. And at the same time, it says that the obligation to avert climate change past 1.5 degrees global warming is an obligation for all states, right? So the court here doesn't create new law or obligation, just says what's already known. However, I do think that there is reach here to the private sector because the duty to regulate applies, and the due diligence obligation for states to avert environmental harm means that they have to regulate in accordance, and it has all the implications, as Francesca has mentioned, for example, fossil fuel exploration in the future. And I think it will be difficult to maintain that if, we are now reaching the 1.5 degree limit, any new fossil fuel exploration could be indeed, any new fossil fuel permits could indeed be lawful. I think it creates huge legal uncertainties whether they will still be lawful if we read this in a literal sense and apply it to fossil fuel exploration.
Excellent. So we have 4 minutes left, which gives us 1 minute for each panelist for an answer for the final question this morning. So as we look ahead to COP30 in Brazil later this year, what needs to happen there? And maybe to make it even a little bit more specific, what decisions need to be made and what new commitments need to be announced? Maybe you can name just one, so that you would feel confident saying, yes, world leaders actually have heard the ICJ. I'll give you a second to think about that. And then I think we can begin maybe with Markus as also the first speaker this morning.
Yeah, thank you very much. I think one of the of course the entire opinion is important for climate negotiations going forward. It's going to be important for the global stocktake, the next one. I think what needs to be underlined is that not having an ambitious NDC, not having an NDC, the discretion of which for states is reduced by the duty to comply with the international scientific best available target is a violation of international law, right? So far too many countries haven't updated their NDC, and so one of the immediate effects, I think, will be a very direct push. I also think countries, the court makes it very clear, countries are responsible for businesses that are emitting from their countries. So NDCs that don't include measures concerning the private sector might also have to be reviewed very carefully in the light of these climate obligations.
Thank you. So updating NDCs and doing so in an ambitious way. Joana, what would be your commitment or your decision that you would like to see?
Yeah, so with that COP idea, right? What we, I think, what is speaks to the COP. I agree with Markus. And if you look in terms of how many countries already submitted, so out of the 195, 20-something countries only submitted so far. They all had already to have submitted, but it means that these who haven't yet, I don't think they will incorporate, but in next rounds of NDC, we want to see that AO reflected. And at the same time, immediately, what we need to see is that the NDCs are translated into action. For me, this is a key issue, that you can make as many promises and commitments in the NDC and go nowhere. So what the AO also emphasizes and strengthens is that those commitments will have to be translated into domestic legislation, and that we can track and we can push and monitor. So that's my key point, translating NDCs into legislation.
Got that. Okay, Francesca, 30 seconds for you.
I agree with everything that's been said, and would just add that for one, fully equipping the loss and damage as well as the climate adaptation fund, and agreeing on no longer subsidizing fossil fuels. Ideally, also agreeing on a phase out, but at least agreeing on no new permits for fossil infrastructure.
Great, Tim, you have the last word.
Thank you. Yes, for all those that were still in doubt, I think the advisory opinion has clarified that climate law, including the Paris Agreement, is not optional, discretionary, or soft. And so I think this will guide the COP process further. I think it's an opportunity to strengthen the COP process because it is the one that states have agreed on, that has wide buy-in. And on the substance of what will happen in the next steps, I completely am aligned with what Joana Setzer has said on the NDCs and the new submissions that will guide kind of the new benchmark for this.
Thank you for this sum up. So I'd like to thank everyone, all our panelists, for their contributions today. I would like to thank the audience for their questions. This was actually our last DGAP morning briefing before the summer break, and we will return with a series in September. Until then, I wish you all a restful and hopefully enjoyable summer. Thank you for joining us today, and goodbye. Have a good day.